Now that you are ready to begin your investigation, investigations must be conducted in a thorough and detailed manner. One of the first things you must do is come up with a plan. Failure to plan a workplace investigation, which actually happens a lot often than you think, is going to result in not a very thorough and acceptable investigation. Depending on the type of complaint you're looking at to investigate, the investigation may require multiple components, and that will vary based on numerous factors such as the type and volume of documentary evidence there may be, how many witnesses there are or lack thereof, the accused's past history of allegations, and the complainant's emotional well-being. So beginning workplace investigations with an idea of the scope of the investigations, such as which questions to explore and answer, as well as a roadmap of how the investigation will proceed, is critical. Keep in mind that the plan may change. You might decide not to interview a witness, or you may decide to add a witness to your list. And you may realize that you need to review, analyze documents that you didn't know existed, or you need to expand the scope of the issues that are involved in the investigation. So from the onset, it's essential to keep in mind that the investigation and the documents and the witnesses will evolve as you go through the process. Next, so we've listed here 7 steps and standard procedure that all thorough and fair investigations generally follow. Review the complaint and any other documents that are submitted. Identify a preliminary list of documents that you must or will need to review. You want to identify the witnesses, evaluate the need for any supplementary interviews that you need to conduct, determine the order of the individuals that you are going to interview and the format the interview will take place. You want to also check for any past allegations and make sure you conclude your investigation at the end and prepare a report. Starting with reviewing the complaint, next, you want to determine, as you are reviewing the complaint, if there is any crucial information that might be missing. If that is the case, reach out to the complainant as soon as possible to get that information. Come up with as detailed or develop as detailed an understanding of the claim as possible. Begin with establishing a timeline of the claim as you understand it. The timeline will expand your investigation the timeline will expand with the investigation as your investigation progresses. Next, you're going to develop a list of the relevant parties to interview, beginning with the complainant, of course, the alleged wrongdoer, or anyone else named in the complaint, and again, evaluating for any supplementary witnesses. Supplementary witnesses are usually individuals who are not necessarily directly involved with the issues or the complaint, but that may be supplementary to the issues you're looking at. Next, a list of the documents that you should review that you will need for the investigation. These will include oftentimes the handbook or the relevant policies. If it's a discrimination or harassment or retaliation claim that you're investigating, you want to review the prevention policy that the employer has, any workplace violence or workplace conduct policies, grievances policies, any memoranda or notes about the incidents that were submitted or that exist, and prior investigation files, if there are any. With respect to prior investigation files, those will also include records of prior complaints against the wrongdoer, records of prior complaints by the complainant, the personnel files of the individuals involved, relevant business records such as time cards, calendars, even parking entries and exit logs, and any other physical evidence that may exist. Make sure that there isn't any physical evidence that you overlook. So that's why it's very important to also look for any physical evidence if there is any. Next, you're going to identify the interviewees and the witnesses, planning the list of persons you are going to interview and the relationships to the matter under the investigation. So your list is going to include, as I had previously indicated, the individual witnesses you're going to interview and also the supplementary witnesses that you might interview. And at this stage, I want to point something out to keep in mind as you're preparing for the interview is to be careful whether you're investigating or any person investigating the complaint, that the interview does not turn into a witch hunt. And it may be possible that during the investigation process, the investigation may become convinced that one party's version of the events is true, and there is a danger that he or she may then steer the investigation into that direction. So to perform a legally compliant and effective workplace investigation, you must be sure that the investigation does not turn into a witch hunt, or it's an unbiased, as Pooja had mentioned already earlier. Next, once you have identified your witnesses, you then want to determine the order of the interview. You always want to ask yourself the following question: is there a reason why you are not going to interview the complainant first? Mostly that would be the starting place of your interview. Should the alleged wrongdoer be interviewed second, last, or in some other order? Generally, you want to interview the witnesses named in the complaint before you interview the alleged wrongdoer. And now this is a general order, and in rare circumstances, you might deviate from this order, this general order. Next, you want to determine the format of the interviews. The format of the interviews may vary based on the person you're going to interview, and you may not always follow the same format for each interview. For recording the witnesses and the witness provided information, the options to consider are contemporaneous notes dictated, typewritten notes, or statements written out by the witnesses in their own words, transcription by a court reporter, or tape recorded or tape videotaped interviews. Next, things to consider if you are going to record the interviews. You want to always check with counsel to review applicable restrictions on your ability to do any recording of the interview. If you're going to record, the recorder should be placed in plain view in front of the witness, and their consent must be obtained. As soon as the recorder is turned, you want to state the date, time, place, and then the witness should affirm on the tape their acknowledgement and consent of the recording. You want to make sure that each interview that you're conducting always starts on a new page as you're recording and documenting your notes. Always identify the date, the people involved and present, and the time and place of the interview. Take very detailed notes, almost as verbatim as possible. At the end, review the notes with the interviewee to confirm the accuracy. Ask and determine if the interviewee has anything else to add. Review your notes and finalize them immediately. Notes should be free of grammar and spelling errors, because these can potentially be used to discredit the interviewer's credibility, or discredit them in the course of the litigation if litigation ensues later. Next, when you're taking notes, do not include your own interpretation, beliefs, assumptions, or conclusions. If you note information during the interview that impacts the credibility, you should note it separately on a different document. You don't want that to be your actual interview notes. Your impressions should not be your actual interview notes. Some things to consider as far as determining the credibility of the witnesses are contradictory statements, of course, facial expressions, defensiveness, or any other expressions of demeanor that you may observe. Moving to the actual interview, you want to prepare an outline of the questions you're going to ask. Have a roadmap with every individual you're going to interview. Maintain a professional demeanor with the witnesses. Determine the extent of personal as opposed to hearsay knowledge that the witness is providing you. Ask open-ended questions rather than leading questions. For example, an open-ended question would be, how did you respond to the statement? And not, did you tell him his statement made you feel uncomfortable? So the second statement, did you tell him his statement made you feel uncomfortable, is a leading question. The reason you don't want to ask leading questions is that those questions limit the ability of the witness to provide all the information they may have. Ask follow-up questions to make sure that you received and obtained sufficient and detailed information from the interview. Ask for any supporting documents the interviewee may have, and note whether the witness refuses to review or sign a written statement, and any reason they give for their refusal to do so. Next, things to not do during the interview. You don't want to obviously intimidate the witnesses. Don't promise absolute confidentiality, and don't tell witnesses that their statements will be kept off the record, because again, as we all know, complete confidentiality in these circumstances can never be assured. And you want to let the witnesses know that. Again, ask leading questions, because that allows the witness to provide their own facts. When interviewing the accuser, the person that made the complaint at the beginning, the individual should be told that the company takes the report seriously and will investigate thoroughly, that the investigation will be confidential to the extent possible. Company does not tolerate any type of retaliation for making a report of misconduct or harassment, and that they must immediately inform either an investigator, human resource, or any other individual that they report to of any perceived retaliation or further instance of misconduct subsequent to them making the actual complaint. Next, general rules to keep in mind during the interview. The interviewer should be sensitive to the issues being raised, get a description of each incident, including details such as date, time, place, nature of the conduct, identity of witnesses, including any other person that may have been harassed. Moving on, for each incident, ask whether there is documentation of the harassment. Don't assume, if you haven't come across any documents in a few witness interviews that you may have conducted, that none of your witnesses or no individual is potentially going to have any documentation. So you want to ask that of every witness that you speak with. Ask follow-up questions and ask detailed questions about every single incident, because there may be more than one single incident. And follow the same line of questioning for each incident as you're covering it. You want to determine and record any limits, if any, of the complainant's cooperation. Determine the complainant's reason for delay, if there was any delay. Consider asking what the complainant would like to see done to ensure the problem does not occur. Next, determine if the conduct has any effect on the complainant, but do not suggest any effects such as emotional damage, trouble sleeping, or any other effect. This is actually key. You don't want to suggest anything. The complainant may not have any of these symptoms, so may not be experiencing anything. So just be very mindful of not suggesting any effects. Explore the need for any interim action while the investigation is pending, and consider whether to prepare and ask, but do not determine the complainant to review, correct, and sign a written account of the allegations after the interview. If the complainant refuses to sign a written statement, you want to make a note of if there is any reason given for why they're refusing to do so. When interviewing the alleged wrongdoer, you want to inform them of the following at the very beginning of the interview. The purpose of the meeting is to ask about the allegations of workplace conduct prior to the meeting. No conclusions have been reached. The interview is his or her opportunity to provide their version of the facts at issue, and full truthful cooperation is expected from everyone involved in the investigation. Moving on, you want to make sure that you let them also know that they are prohibited from interfering with the investigation, for example, by talking to other employees about the allegations or the subject matter of the complaint, and any retaliation is forbidden. So you just want to make sure that everyone involved is aware that they have a right not to be retaliated because they're participating in the process. Examples of retaliation is the verbal misconduct, denial of overtime. If you're talking about if the alleged accuser is a supervisor, there could be denial of overtime or any other job benefits to the complainant, any employee involved in the investigation, or rebuking or rebuffing the complainant or any employee involved in the investigation. Next, exploring any working or personal relationship between the complainant and the alleged harasser. Ascertain the relation if the alleged wrongdoer to the complainant, for example, whether the wrongdoer is an agent of the company, a supervisory employee, or a co-worker, or a non-employee. Next, you want to learn the extent and nature of the interactions they had with the alleged victim. For example, determine whether there were any gifts exchanged, cards, notes that they may have, and if there's been dating or if that was a strictly working relationship. Inquire about the behavior of the complainant and the alleged wrongdoer during the time surrounding the allegations. You want to ask about potential witnesses, and note that if the wrongdoer refuses to provide a signed written statement, the reasons given for refusing to do so. When interviewing other witnesses at the onset, you want to let the witnesses know the purpose of the interview is to investigate the complaint, and that their full cooperation is essential. Moving on to any follow-up interviews you want to do, you want to determine, and you basically follow the same process with your follow-up interviews. When investigating a verbal harassment incident, determine the nature and frequency of the context and the intended target of the alleged remarks. Was the complainant singled out? Did they participate in the banter? What was the relationship of the individuals involved? Were the remarks hostile or derogatory? And an example of whether it was a quid pro quo harassment. The investigation must determine the validity of the supervisor's stated reason for the adverse employment action. And finally, here's a list of mistakes to avoid as you're conducting the investigation. You obviously do not want to secretly record any interviews, telephone calls, or intercept any emails. And do not keep a witness in an interview site against their will. Do not reach any conclusions before the investigation is over, and conclude the investigation and prepare a report.